come on to tell you that you had been involved in an accident?
No.
When you arrived at home, what did you do, or what did you notice about your car?
When I parked my car and I got out, I did notice the damage to the car.
Okay. And then what did you do?
I went inside and I told my boyfriend about it.
And after you go in, you notice the damage to your car. What were you thinking at that point?
I have a friend that works for an auto shop, so I decided to call him to try to get the window fixed.
Now, we've also seen, and it's been admitted into evidence, the cell phone download that shows you started Googling breaking news near me.
Yes.
Why did you start to do that?
When I noticed all the damage to the car, okay, this is not from a pothole, something probably happened, and then I started to Google anything that happened in that area.
Okay. And how many times did you Google that information?
A few times.
Now, we've seen the text messages about you wanting to fix your windshield.
Yes.
Explain to the jury what you were thinking when you were having that conversation through text.
Through the text messages. At that time, it was later on in the day after I already seen on social media and on the news that a child was hit. And when I first seen it, it said critical condition. So I was like, okay, that's about like the Googling and stuff like that. That's what prompted me to keep checking up on it.
And the Google shows that you Googled that some of the same information multiple times. Why did you do that?
I was looking on any updates.
What was there's been testimony that you were panicked.
Yes.
Can you describe to the jury your panic?
It was once I seen that a child had passed away and I knew that it was me in the car that did it, I wanted to die. I couldn't speak, I was throwing up, I couldn't really move. Words wouldn't come out when I tried to talk to anyone.
Can you describe for the jury what has been said to be a borderline crazy?
I think he said that because when I called him later on that morning, I was telling him that I wanted to kill myself. And if no one was in my house that morning, I would have done it.
Where did you park your car when you arrived at home?
It was like maybe 2 doors down from where my apartment was.
And although you had those conversations with Mark, did you do anything to fix your windshield?
No.
Did you do anything to try to repair your car?
No.
Did you ever move your car from that first position when you parked it and arrived at home?
No.
When you first called Mark, shortly after this accident, at that particular time, did you know you had hit a child?
No.
How did you find out that you hit a little girl?
I had seen it on social media around 8 o'clock in the morning.
Now, once you saw this information, did you make arrangements to turn yourself in?
Yes.
Tell the jury, what did you do in making those arrangements?
I had called my mom, and she came from Okeechobee to come pick me up, take me to the jail.
Yeah. And how long did it take your mom to get from Okeechobee to your apartment?
45 minutes, maybe an hour.
When you arrived at the jail, was law enforcement expecting you?
No.
Did they have any idea who you were?
No.
Did you tell them where your car was located?
Yes.
Did you also give them access to your phone?
Yes.
Did you do anything to hide the fact that you were the driver or to hide your car on this particular day?
No.
Did you intentionally leave the scene of that accident knowing that you had hit a little girl?
No.
At the time that you drove past the bus, did you believe or know that you had hit anyone?
No.
No further questions?
Sir. Hi, ma'am. You were driving that Chevy Cruze, correct?
Yes.
And you were driving that car after having been at work starting around 4 o'clock the day before, correct?
Yes.
And you worked until about 2 o'clock a.m., right?
Yes.
Okay, and then you went and hung out until about 6:30 with those two gentlemen at the house, correct?
Yes.
All right, so you were driving that car after being up for a minimum of at least 14 and a half hours before the crash, correct?
Yes.
So you were tired.
Yes.
Yes, you were tired. And that's a straight shot down Oleander. Yes. And it's still, the sun has not come up yet, so it's still dark, right?
Yes.
All right, and you'd agree that in the darkness, a light will be more visible than even in the daytime,
Yes.
correct? Yes, that's why we have flashlights, right?
Yes.
They're more effective if they're used in the dark than in the light, correct?
Yes.
And a school bus has many lights, doesn't it?
Yes.
Yes, projecting all over the place, right?
Yes.
As well as reflectors.
Yes.
And so you saw that school bus from a good, I think you testified from afar, from a good distance south of that intersection, correct?
Yes.
Yes. And you knew the school bus was stopped and the lights were on, right?
Yes.
And you understand, of course, that when a school bus is stopped on the side of the road, particularly about 6:30 in the morning, children are getting on school buses, correct?
Yes.
Yes. And you understand that your obligation as a driver is to stop.
Yes.
Yes. However, you assumed that all the kids were already on the bus, correct?
Yes.
Now, you can't see off onto the shoulder and the sides of the roads because there's not, street lamps, right?
No.
So you only have what your car is illuminating in front of you, correct?
Yes.
All right. So with that knowledge in mind, you decided to take a calculated risk because you don't see any children. You're going to just ignore the stop sign and keep going, correct?
Yes.
Yes. And that's a reckless action, correct?
Yes.
Okay. All right. And because you consciously chose, you saw the bus, you knew it was there, you saw the stop signs, you believed there were probably kids, but you thought they were on the bus, so you took a conscious decision to just keep driving, correct?
Yes.
Yes. Not stopping or slowing down, right?
No.
Right. All right. And so that was a calculated risk on your part, correct?
Yes.
Yes. And you were wrong, correct?
Yes.
Yes. And Yesenia and her family have paid the price of your gamble.
Judge, I'm gonna object.
It's a legal objection.
Hearsay.
Yesenia Gonzalez, a 10-year-old girl trying to go to school, and her family have paid the price for your gamble, correct? Your reckless gamble. Yes, okay. And you struck and killed Yesenia, didn't you?
I didn't know I hit someone at the time.
Okay, ma'am. You admit you struck and killed her, correct? As you sit there today, you know that, right?
Yes.
You ended the life of that little girl
Yes.
because you were impatient. Yes? Yes, please answer the question.
Yes.
Yes. I mean, you were only a mile away from home, right? Or a mile and a half, right?
Mm-hmm.
And that's yes?
Yes.
And you didn't have it within you to stop and wait for 15 seconds just to make sure every little child got on that school bus safely, did you?
No.
You didn't care about the life of those kids. Did you?
I wouldn't say that.
Well, you drove a vehicle at more than 40 miles per hour right through the group of children crossing that street, didn't you?
See no kids crossing the street.
Okay, so let's now, I want to challenge that. I'm going to pull up the exhibit, and I'm going to I'm going to approach the clerk here just to make sure I get once I have it up. All right. This is the school bus video, which for the record, the exhibit number. I apologize. I don't have this. Bus video. Okay, this would be, yes. This is State's Exhibit 2. I got to connect now. I apologize. Okay. All right. So you see your car. Okay. First of all, the time is 6:33 and 40 seconds. You see the front bar come up forward at the bottom of the screen. This white. Yes, you see that?
Yes.
Yes. Okay. All right. And the car approaching, that would be your car, correct?
Yes.
Yes. And you testified now. You were fully aware that that school bus was stopped on the side of the road, correct?
Yes.
And you knew that there were kids in the area, correct?
Yes.
Kids, because they get on and off school buses, okay? And we see as you're approaching closer, whoops, this young boy, he's directly in your line of sight, correct?
Yes.
Okay, so you saw him.
No.
You, from that distance, with your headlamps on, with the school bus illuminating the road directly in that, right there, you're telling me as a driver, you cannot see a pedestrian walking directly in front of your line of sight?
No, I didn't see.
Were you looking at your cell phone?
No.
How's you can't see a boy standing directly in front of you?
Not from where I was.
Okay,
right
well,
now.
let's go a little bit closer then.
Okay.
All right, he's still walking. You're getting closer. Okay, now, this boy is standing directly in front of your car. I mean, you're less than 300 feet away. You are 4 seconds away from striking Yesenia, and you're still saying you don't see this boy standing here.
No.
All right, well, let's try one more. Okay, child number 2. You are within 10 feet of that child. And I'll go back for a second if we'd like, because I know it happens quick. Boy clears the intersection, child number 2 coming, stepping onto the road. You saw that child at least, right?
No.
Because you were looking at your phone?
I was not on my phone.
Because you were tired? I mean,
I
how did you not see these children?
did not see them.
Okay, I'm going to be glib, but how about child number 3? Bam, Yesenia. You saw her hit your windshield.
No.
This is State's Exhibit, I believe it was 12. That was caused by the collision when you ran over and into Yesenia, correct?
Yes.
That's your windshield, correct?
Yes.
You can see through your windshield, correct?
Yes.
So you saw yourself hit Yesenia and her go up on your windshield, correct?
No.
Is it because you can't see that part of your front of your car?
Yes.
Okay. Let's find out what your car looks like. All right. Here we go. This is you driving your car earlier that day, correct?
Yes.
All right. Okay. Here you can see if someone were, I get it. This is a road that has street lamps. The one you're on doesn't, right?
Correct.
And that would mean you actually exercise more caution if the road is darker, correct?
Yes.
And it's okay. So you should have been more cautious than you are in this video, correct?
Yes.
Okay. So nonetheless, your vision allows you to see off to the right and to the left of what's in front of you when your lights are on, correct?
Yes.
Okay. All right. Boom. You're telling me from your vantage point at the driver's seat, you can't see any object that impacts this portion of your windshield?
In this video, yes.
What do you mean that? No, as you sit there, as you sit in your driver's seat, you're telling me you can't see 8 inches to the right of your peripheral vision?
Yes.
No, hold on. You're saying you don't have peripheral vision?
No, it's, yes.
You do, right? Okay. So because you have standard human peripheral vision, you can see to the right and to the left of your windshield, correct?
Yes.
And you struck her on your windshield. Yes, right?
Yes.
So therefore you saw her.
I did not see her.
You heard the noise.
I did, yes.
All right. And you knew there's a school bus, and you certainly knew there's the potentiality of children. Hold on, Judge. All right, let me just get this back to. All right. So you're telling this jury here that you did not put 2 and 2 together, that when you heard the noise, bypassing a couple of stop signs on the school bus, knowing that's the time of day when kids get on and off the bus, you never thought that, you know what, I might have just hit a person.
No, not in that moment, no.
How come?
I didn't see the damage all the way to the side.
I gotta ask, were you aware of your surroundings?
Yes.
But you didn't see yourself hit a child or think that maybe you just hit a child when you just blew past an intersection with a school bus?
No.
Okay, all right. So then you get home and you're saying, you get home and then you say you see the damage, so you call your boyfriend.
I went inside my house.
Okay. Went inside and called him.
No, he lived with me.
Got it. All right. So your boyfriend's not baby?
Yes.
Okay. So let me go to. All right. So here we go. Outgoing call. Baby. All right. This is at 6:34 and 28 seconds. It's a 3-minute call to baby. Okay. That is the crash we know was at 6:33 and 57 seconds. So this is going to put us about 32, 33 seconds after the crash. You called him for 3 minutes, right?
I don't remember.
Oh, I'm sorry. This is it's the system here. Let me go back to the screen. And for the record, this is State Exhibit, I believe, 17. And I'm putting it up on the screen. Oh, okay. All right, so you call your boyfriend, who lives with you, at 6:34 and talk to him for 3 minutes. Okay?
Okay.
All right. You're almost home, but you feel the need to pull out your phone and call him, even though you're only a mile and a half from home. Right?
I don't remember calling him on my way home.
And so you're saying you don't remember the conversation you had with him after you heard this loud noise, because you're at least admitting to hearing it.
No.
You don't remember what that call was about?
No.
Not at all. Okay. So then you just park the car and go inside.
Mm-hmm.
That's yes for the
Yes.
record? Still unaware of any damage to your vehicle?
No, when I got out the car, I saw the damage.
Okay, so then you went inside, and you're saying after you got home, you see the damage, then, only then, do you call Mark,
Yes.
your mechanic friend?
Yes.
Okay, because you see the damage, and you think that that damage was caused by a pothole.
No, when I seen the damage, I said this wasn't likely a pothole. So that's when I called to get the windshield fixed.
Okay, and we know then you called Mark, right?
Yes.
And that's 6:39 in the morning, correct? Right here, the next one, 167.
Yes.
Okay, all right, and you talked to him for about 2 minutes.
Yes.
And you're freaking out, right? Panicking.
When I called him at that time, no.
Oh, you're not?
No.
You're very calm?
I wasn't calm. I was just asking him if he could help me get my windshield fixed.
Okay, but you just testified that you knew it wasn't a pothole, right?
Yes.
So you're saying at that point you had enough awareness that you may have just hit a person, right?
That wasn't my thought, no.
No, didn't you just testify, I got home and I realized it wasn't a pothole?
Yes.
Okay, so if it's not a pothole, then you reasonably believe that it could have been a person.
My thought wasn't a person, no.
Oh, your thought was,
It's just something happened. I obviously hit something. Never once thought I hit a person.
okay. So at no point do you think, wow, I might have hit a person. Instead, your thought goes to, wow, I need to get this replaced right away, right?
Yes.
And you need to get it replaced because you know you're going to be identified as the driver who struck and killed that girl. That's why you want it replaced, right?
Later on that day, yes.
Okay. But not before then? So why call Mark again and again and again throughout the morning, your mechanic friend?
When I seen on the news and on social media about her getting hit and it was on the road, I had a picture of my car and I realized it was me, I did, in a state of panic, think to get it fixed.
Mm-hmm. All right. So you have conversations back and forth with Mark about getting it fixed. And then this is 12:46 now. At this point, you're saying, you're admitting here today, you knew full well what you did at 12:46 that day, correct?
Yes.
Yes. All right. Because you testified earlier that at 8 a.m. you became aware because of social media, and then you began to make arrangements to turn yourself in. As we testified to on direct, correct?
Yes.
Okay. However, we know from your text messages, you're not making arrangements. You're, quote, fucking freaking out. Please help me. And you go on to say, people are going to see my car and probably say something. I can't go to jail or prison. I just can't fucking deal with this. How do you think Yesenia's family was dealing with this at that point?
Objection, speculation.
That's a speculation.
I can't wait after hours. I can't. This shit is going to kill me. Interesting use of phrase.
Judge,
Waiting for
Judge, I'm going to object to the commentary. If there's not a question, Mr. Lowe.
I'm developing the question. I'm sorry.
Judge, you shouldn't be commenting.
Counsel?
Yes, sir. So it's going to kill me waiting for this guy. A fucking cop lives above me. Man, this is at 12:49. Your goal at this point is to cover up the damage to your vehicle, correct? Because you know what's going to happen if someone sees your vehicle and knows it's yours.
In my state of panic at that time, yes.
Okay. So it wasn't true when you said, as soon as you found out on social media, you then made arrangements to turn yourself in. That wasn't true when you testified to that, was it?
I did make arrangements to turn myself in.
Right. Well, 8 hours later, but initially your goal was to get your vehicle fixed.
That was my first.
Yes. Okay.
Yes.
Go ahead and take that. One moment, Your Honor. All right, man. So, just to sort of wrap things up, you were the one who caused the crash because you chose to blow through that intersection, right?
Yes.
And in doing so, you collided with Yesenia, correct?
Yes.
And although you're saying today you didn't know, you would agree with me that a person in your seat, a reasonable driver, should have known of the crash.
I didn't know.
I'm saying you should have known based on the circumstances, correct? Based on everything that, a direct frontal impact with a child.
Judge,
I know you're saying you didn't know.
Judge, I'm going to object. Ask and answer.
Same. Next question.
All right. I don't have any questions, Judge. Thank you.
Anything direct?
No, sir.
Ms. Willing, you may step down and join the attorney. Mr. Stone?
Judge, defense has no additional witnesses to address.
Counsel approach. Ladies and gentlemen, at this time I need you to step into the jury room. need your note pads down on the seats still. Other deputy, with you in just 2 moments. All right, everybody will be in about a 10-minute recess.
All rise, please. Ladies and gentlemen, the court says recess. Give them recess.
Okay, I guess we can get our microphones.
I don't know who else, there may be somebody else testifying.
Think so?
I would leave the mic up there at least until lunch.
Okay.
I had one other thing I had to, the head kept bobbing in and then she turned, so I had to raise the camera up at the last minute. Wow. You need this, hey, you need this up there for anything else? Okay.
Coming up in Bunny?
Yeah. See if I can get this done. Hey, how you doing?
Living the life. Life is living.
What? Okay. Unplug it. Hey, they're in skirts. Ladies, if I can, operate or the,
One more time, please. This was around 8:20. Because I just quick look. And then this one, another one.
yeah. I've been here since, I've been up since 1:30. So, and I've been here since 4 this morning.
Hey, what are we doing for audio?
I have my mic there.
Okay, just put
If
it.
you have a reversal, they have the wrong connector.
Oh, probably not.
Not at all.
Okay.
Because I think the microphones here, I don't think that's an output.
Because there was there's one in another courtroom, which is audio, but it has the wrong connector on it, so I used it 8 years ago.
You can stay right there. I'm Liz. Nice to meet you.
You need a TVU?
No, I have. Well, I have one. Do they want to stream it?
I don't know,
My colleague.
I was told to,
Okay.
provide a fee.
Yeah.
She wants to
I
go
don't
to
want to
state.
streaming it.
Well, I guess I can go down and get it.
Thank you, the state attorney's office. Thank you. Reading everyone that's been here for the-
Come through?
Hey Bob, where did you plug that into?
You see where Alpha's at, yellow? You need to, yeah. There's a plug, the bottom plug. Where the girls are? Is where I was
Probably
plugged.
get something for you, like it doesn't matter what happens to it, because we're talking about the impact on some of the things that she's oh, yeah. Yeah. We're speaking. I will give her questions.
A little bit, a tiny bit, but we have several Spanish speakers.
You better bring it down the local result.
Yeah, that's fine.
So you're gonna go over this, over the.
Is there one underneath? I see. Oh, that's
It's all the way,
that.
it's all the way in the back, it's hard to get, you have to lay down on the floor.
Okay, that's fine.
It's elevated a little bit, not like West Palm, it's not good.
Figure out.
You have to lay down on the floor, you're.
Can I get it on here? I'm gonna get under.
Okay, go. I'm sorry. Go under.
Oh, that's not too bad. Bob, but no, wait, you got yours unplugged, right?
Yes,
I just get confused with this yellow.
mine was plugged in on the bottom one. Unless it was changed, I'd plug in on the bottom, I'd extract it from the bottom.
Okay, cool. And then I could probably wrap this around down here. So it's not okay.
Family's all very thankful to
And then you're gonna have to,
Mr. Miller here.
yeah, they won't let you go through the other way.
Everybody does. No, it's an honor. I know about this case, it's unbelievable. I go to Okeechobee, they know about it. I go to
I think I was out here before the.
No worries, you got time.
He's an officer that testified yesterday as to the velocity of the vehicle at certain times. What was his name? Yeah, he's from Okeechobee. Yeah, something to Gardino. Yeah, something. Yeah. And he's still in Okeechobee. I think so too. Yeah, because I was talking to Ashley.
Let me see if I can go down, I know there's a.
Yeah, you guys have a good guy. You can use him. Yeah, so they could come in so handy. Very good.
All right, Bubba. I'm not, I got it, bud.
Did you push your mic a bit?
Can you turn my mic on? No, it's over there. Yeah. Thank you. Did you turn it on?
Yeah.
Is it on?
You know when it's on. Is it on?
It's on.
Yeah. Okay.
All right, you are back on the record, State of Florida versus Ariana.
Judge, my time will be right.
That's fine. 2021 CFP 405. Mr. Miller, are you asking the clerk to give you a warning at any point?
Yes, I'm requesting hour and 10 minutes, I think, because we've got some additional testimony. So if I could get a warning, really at 15 minutes, 5-0, if you get a 5-minute warning at that point, I'll try and wrap up. Meeting about 15 minutes. So 15 minutes, just say, the warning, I'll know that that's about a 5-minute warning.
Thank you.
I appreciate that.
Mr. Stone, do you want any warning on the time you'll have an hour and 10 minutes?
No, Judge. If I go over, hold on, leave it.
back on the record of the state of Florida versus Ariana Colon, case number 2021 CF2405. Ms. Colon is present with counsel. Mr. Miller for the state. Counsel, you've had an opportunity to review the final draft of the instructions and verdict form. Are there any objections or corrections?
Not from the state.
Judge, from the defense, I just renewed my request, and we'll leave that as a standing request for public purposes.
All right, subject to your earlier
Yes.
requests and your objections to
Correct.
the form, do you see anything different?
No, sir.
All right. All right, we each have an hour, 10 minutes. State you have a warning at 50 minutes. Are you both ready for the jury to come in?
Yes.
Yes.
Also, as a reminder, if you have cell phones, make sure they're in a silent mode. Cell phone silent mode.
All right, all members of the jury have returned. Everybody please be seated. Both the state and the defendant have now rested their case. The attorneys now will present the final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time. The state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Miller.
Thank you, Your Honor. All right. I realize I can show you the school bus video. You can see the crash for yourself. You can see the defendant leaving the scene of the crash, and we know that she was the driver and the child was killed. I could do that and say that proves the charge beyond any reasonable doubt and sit down. I realize you have everything right there. But I'm not going to run through this quickly. I'm going to go take my time to go through the evidence. You sat there patiently, attentively listening for the last 3 days. And so I want to make sure this is the opportunity I have to prove to all of you, unanimously, all 8 of you, beyond any reasonable doubt, she's guilty of these 2 charges. I think there's really only 3 questions that we have to answer here. Did the defendant kill Yesenia? Yes. At the time, was the defendant driving recklessly? Yes. And now you've heard from her own testimony, she admitted she was driving recklessly when she struck and killed Yesenia. And did she leave the scene? Yes. So because the answer to those questions is yes, we have vehicular homicide. That she was driving recklessly and killed a child. We have leaving the scene involving a death, because the crash involved a death and she left the scene. That's what she's charged with. That's why I'm asking you to find her guilty. When this video begins, we know the time. It's 6:33 in the morning and 40 seconds. We see the lights flashing, and we see the defendant's car approaching. And we can see the intersection of Skylark, so we know the relative position of where this crash occurred in relation to Skylark, on Oleander. And we're going to see for 17 seconds, the defendant is barreling down the road, and now we know she was aware of the bus. And yet she continued at approximately 40 to 43 miles per hour. The last registered time on her car was 43 miles per hour, and that's 43 miles an hour over the speed limit. Because although the speed limit is 35, that only applies, of course, when there's not a school bus with a stop sign engaged. When the bus stops and the stop sign comes out, the speed limit becomes 0, because even if a car rolls through at 5 miles an hour, it's running the stop sign. It's driving recklessly. So she's driving 43 miles per hour over the speed limit at the time of this collision. And so for 17 seconds, as multiple children cross the street, one of which just crosses in front of the defendant, coming here, very nonchalant, doing the same thing I'm sure they do every single day, expecting the car to stop. Another child about to step in the road, jumps back. Yesenia's life is over at that point. We're going to see her coming, her shadow coming across the screen, right here, middle of the screen, coming, walking, flying from others' cries. There we go. We see Yesenia's mother's car parked right here because we see the headlamps. We're going to see Yesenia, her silhouette, cross in front of her mother's car, headlamps. Here she comes. Just to outline, let you know where we're going with this. Of course, you're welcome to take notes. The judge is going to provide you with legal instructions once we're done, and much of what I'm going to be presenting to you are just simply the law, the legal instructions. You don't have to write down, if you don't wish, everything I'm saying, you'll get it. But we're going to talk about the charges and the elements, rules for deliberation that apply in every case, go through the timeline in a meticulous fashion. We're going to talk about the instruction on weighing the evidence, how you can determine which evidence is reliable and not reliable. Summarize the evidence, which is both testimony and exhibits. Talk about the standard of proof and the verdict form. Count 1, leaving the scene of a crash involving death. To find her guilty, you must determine 4 things beyond a reasonable doubt. First, that the defendant was the driver of a vehicle involved in a crash on a public or private property, resulting in the death of the victim, of Yesenia. So that she's the driver involved in a crash, resulting in death. Second element, that she knew she was involved in a crash. Of course, this would be by the sound and the sight, as well as all the circumstances, knowing she was involved in the crash. Third, that she knew or should have known, from all of the circumstances, including the nature of the crash, of the injury or death. She doesn't have to know of the death, right? Just knew or should have known of even the injury. If you find that element has been met. And then finally, that she willfully failed to stop at the scene of the crash or as close thereto as possible and remain there until doing 2 things. Provide identifying information, her name, her way to identify her as the driver involved in the crash, and also to render reasonable assistance. And that's an objective standard. You determine what's reasonable assistance in this case, in any case. What is reasonable assistance? But what a person cannot do is just drive away. Just run away. You have to stop, provide your information, and render reasonable assistance. Neither of those things were done in this case. Definition for reasonable assistance. This is the law that applies. Includes carrying or making arrangements to carry the injured person to a physician or hospital for medical treatment. It's not as though a driver has to perform emergency surgery on the side of the road. That's ridiculous. No one could do that unless you were a surgeon and you had the tools with you. It's the minimal thing required. Make arrangements so that injured person can get the help they need as quickly as possible. That's all that's required. And then if you find the defendant guilty of this, you're going to be asked a couple of interrogatories. Those are just questions to follow up on the verdict form. One point I want to clarify up front. You then have to determine whether the driver was the cause of the death, because a person could be involved in a crash where a death occurs, but the driver is not the one who caused it. It may have been another vehicle, but that driver, if you're involved and you leave, you're still responsible, right? But it's a difference between if you're the driver who caused the death or a driver who's involved but didn't cause the death. Because sometimes you could have 2 cars involved and one car is at fault, the other isn't. Even the car that's not at fault, if there's an injury or death, that driver must remain. So It puts everyone on the hook who's involved in the crash, but you're just simply asked to further state whether the defendant did in fact cause the death, and of course in this case she did. All right, count 2, vehicular homicide. Element 1 is that Yesenia is dead, clearly without dispute, and of course the medical examiner testified to the nature and cause of death. The death was caused by the operation of a motor vehicle by the defendant. Yes, it was. It was that striking of Yesenia that ended her life. Finally, she operated the vehicle in a reckless manner, which was likely to cause death or great bodily harm to another person. Of course, she's admitted that her, I think saying calculated risk might be generous. It was purely a reckless and selfish act that she rolled the dice, and ultimately Yesenia died because of that gamble. So it's vehicular homicide is just reckless driving with a death. Recklessness is defined, again, she's admitted that it was reckless, but I'll just give you the definition anyway. You don't have to state, I don't have to prove that she intended to do harm, only that she failed to use something more than failing to use ordinary care. So it's not just being sort of careless, it's careless plus. It's a bit higher than that. It's willful or wanton disregard for safety, and willful would be purposeful. This is what's defined in that big paragraph. I'm just summarizing it. And a wanton could be conscious indifference to dangerous actions. So she testified and admitted she knew that kids get on and off buses, that she just believed that all the kids were on the bus, but she was aware there could be kids in the area because, of course, that's common sense. And so she had a conscious indifference as to when she blew past that intersection at 43 miles per hour, consciously indifferent to the danger, the zone of danger she created by the operation of her vehicle. So that was, yes, both willful as well as wanton, which is why it's reckless, which she again admitted to. Some rules for deliberation: you must follow the law. And the law will tell you, the instructions tell you, if you fail to follow the law, your verdict will be a miscarriage of justice. So the elements that define the charges, that's the law. The burden of proof, that's the law. I ask you to just follow the law. Your verdict should be based only on the evidence presented. Evidence is not what I say or the defense lawyer says. Evidence is what comes from the witness stand through, I believe it's now the 17 or 18 witnesses who have testified. This testimony is evidence, as well as the exhibits. I think we're up to 19 exhibits. All of that, that's the universe of evidence you have to decide your verdict. Finally, the judge decides the sentence. It's not for the jurors to deliberate about. You just simply determine whether I've proved the charge beyond a reasonable doubt. Let's go through the timeline. So we know she arrived at work around 4 p.m. on September 22nd, and she leaves around 2:15 a.m., 2:15 a.m., which would put her at about 10, a little more than 10 hours. And why is that relevant? Well, part of recklessness is being tired, not being able to appreciate your surroundings. And so we know she works a 10 plus hour shift. From there, she then meets up with Gallagher and Jones at the racetrack, and they make plans to then go to the house. And again, we see her getting in and out of her vehicle. The video's not in, but the screenshots of those relevant portions are in evidence, and you can see her arrive and get out, and as she's leaving, she's getting in the vehicle and she's driving. And we know that's at 2:36 because the screenshots of the surveillance video gives us the time, so we know that's exact and accurate. At 2:53, she invites her coworker, Carly Vaughn, to join them at White Oak Lane. She then arrives at White Oak Lane, following behind Mr. Gallagher, which we saw in that cell phone video. He's the blue, I believe it was a Lexus in front of her, at about 3:10 in the morning. The next thing we know they left around 6:25 or so, based on witness testimony. Her vehicle infotainment center puts her north on Oleander, traveling north, at 6:30. All right, so leave the house sometime before 6:30 on Oleander. We know from the infotainment center at 6:31 and 33 seconds, which is just shy of 2 minutes before the crash, she's going 59.9. She's going 60, basically, in a 35. That's 25 over the speed limit at 6:30 in the morning. Then we see at 6:33:48, she's traveling now at 43 miles per hour at Fromar Place. This is the intersection just south. It's about 300 feet from Skylark. 6:33:57, she strikes Yesenia, killing her. 6:34:03, again taken from the infotainment center. She, 6 seconds after striking, her vehicle has slowed down from 43 down to 40.6. Perhaps letting off the accelerator upon the collision. But then we see from 6:34:03 to 6:34:18, just 15 seconds, she speeds up 16.3 miles per hour. Ladies and gentlemen, this is a woman who knows she struck and killed a child, or at the very least, severely injured that child. She hesitates as she slows down to 40 and then guns it to get out of it. That's what it is. That's what we can draw from this evidence. Her driving pattern. She knew what happened. How could you not? She knew the sound. She saw it. She felt it. And her thought was, run away. Leave the scene. While she's still driving, before she gets home, at 6:34 and 28 seconds, and she's admitted and acknowledged this call was to her boyfriend, who in her phone had saved his baby. That's a 3-minute call that she makes at 6:34:28. Again, the crash was 6:33:57, so we're talking 28 and 31 seconds after the crash. She calls her boyfriend, who lives at her house. She's only a mile away, and yet needs to call and talk to him for 3 minutes, 2 seconds. At 6:38 now, so things have sort of slowed down. About 4 minutes later, she's at the intersection of Oleander and Virginia Ave. And then upon leaving that intersection, but before she gets home, she calls Mark Carrasco, the mechanic, for the first time. That call lasts for 2 minutes and 13 seconds, and we know that's him because it says Mark on the call log, but also because he identified his number at the time as being 772-203-8688. And she's testified that she did call him. Now, she says she had no knowledge until she gets home and then sees the damage and then talks to the boyfriend and then calls Mark, but we actually know the evidence, right? The cell phone evidence, the driving infotainment center evidence, that is accurate evidence. That's what happened, not what she says, but the actual cell phone records and the infotainment center tell the jury exactly what she did and when she did it. We know from the infotainment center at 6:42, she now arrives home at 2050 Oleander. So the call to Mark is 6:39:44, and then she pulls in at 6:42, and between 6:48 a.m., so now she's home, and 2:21 p.m., she makes 9 additional calls to Mark. And this is all in state's evidence presented today. That would be, I believe, 17, state 17. You can go and count up the outgoing and incoming calls to Mark PR. It saved Mark PR. That's how it's saved in the phone. 7:12, the first time she searches, breaking news near me. Now look, if she thought she hit a pothole, that wouldn't be breaking news. But within less than 45 minutes of this crash, she believes that this event is newsworthy. And so she begins to search breaking news near me. Some hours go by. Those calls with Mark are going back and forth. At 12:42, she searches for the first time, penalty for hit and run with injury. Text messages begin, because Mark says he's at work, so he can't talk. So now we know what's actually being said. Text messages between 12:21 and 2:53. And remember, the first time she searches for penalty is 12:42. So these texts begin a little before that. I'm effing freaking out. People are going to see my car and probably say something. I can't wait after hours, and an effing cop lives above me. I know my neighbors are looking at my car and probably saw the freaking news. That text comes through at 12:55. She's trying to cover up for what she knows she did. Then, at 4:09, or approximate, she arrives at the county jail. So weighing the evidence, this has to do with witness credibility. This is what you consider when determining whether what you heard from a witness or what you saw in an exhibit is reliable, that you can actually rely upon in guiding your deliberations. So this applies to all witnesses, and it says you should use your common sense in deciding what is the best evidence and what evidence should not be relied upon. So a couple things to consider. For each witness, did they have an opportunity to see and know the things they talk about? Do they appear to be honest and straightforward in answering questions? Do they have some interest in how the case should be decided? Does their testimony agree with other testimony and other evidence? For example, Mark disagrees with Mark. In court, he comes in and says, I don't remember the details of our call, but she never said she hit a kid. But then he was presented with his prior statement when asked, Did she tell you she hit a kid? His answer, yes, she did. All right, so that goes to his credibility. Now, the phone records are the records. That's what it is. We know when the calls were made. But when he comes in and he declares unambiguously, definitively, that she never told me she hit a kid, one has to ask, why is his statement inconsistent? Why is what he told Stokes different than what he told you? And even when presented with it, he still would not acknowledge he made that statement. That goes to his bias. That's why he's not a reliable witness insofar as his in-court testimony, which contradicts the other evidence, is not reliable. Because we have the cell phone evidence, we have his prior statements, but for whatever reason, his affection for the defendant, her reciprocated love back towards him, is causing his testimony, and you can use your common sense in figuring this out, to not be reliable. Yeah, and then that's the last one. Did the witness at some time make a statement that's inconsistent with what they stated previously? So I just sort of summarized. The first morning of day one, we heard from the 911 call custodian introducing the 911 calls. Don Carter, he's the custodian for the school bus surveillance video. Zamora had the body cam. Francois found additional video. And Mr. Brollman, of course, was the custodian of that video to introduce it. We then heard from her friends and associates in the afternoon. And then going through 11, 12, and 13, that's the medical examiner and the two officers who met her at the jail. And then yesterday we had the CSI, the person with Deputy Garduno with the infotainment, Stokes, who's the investigator, and of course the victim's mother. And today you heard from Mr. Fernandez and of course the defendant. So I want to just run through this just a couple more times. All right. You can actually see in this rear view mirror, you can see the stop sign come open. Flashing. Of course, this bar is open. Like I said, 17 seconds. We can just sit here and wait and watch. All right. This is also on stage 2. I just sort of cropped it to take out the lower half. We see this child getting out of a car over here. Here we see Yesenia. Sorry. This is just important because there was some testimony about that she was clipped. That's not being clipped. Head-on collision. There's the stop sign pops open. Here's Mary Lou's vehicle. Here she comes. Direct impact, head against the windshield. Officer Zamora, his body cam, this helps us see the road conditions on the day of. Now this is at 6:41, so it's 8 minutes after, not that much later. We see the bus with the lights on, we see the relative width of the road, we see the lighting conditions. Of course, there's emergency vehicles here, I understand, but and we see where she lands in relation to where she was struck at the front of the bus. Officer Stokes testified the average school bus is about 35 to 45 feet in length. She was at the front of the bus when she was struck. She was in the middle of the road. She's now a good 10, 15 feet off of the road. So she's about a good distance behind the bus. He estimated she flew through the air approximately 80 to 100 feet upon impact. And of course, her articles of clothing, her key, her phone were strewn all about both the road and the grass. We can also see from this video, it is a relatively clear morning. We don't see cloud cover. You know, so visibility conditions were in good condition, as Stokes testified to. This is classic car surveillance video. See the bus approach. We're going to see the door open because we see the light right there. That's when the door opens. You can see the light from inside. Here she comes, both headlamps working. Here comes Yesenia towards the front of the bus. Never stops. Keeps going. Let's move ahead. We know what her car looked like. About 30 minutes before the crash, there was no damage to the vehicle because we have this video from J.B. Jones showing his truck at 6:02 on the 23rd. Showing Mr. Gallagher's vehicle. Oops. I don't know why it's doing that. Okay. No damage to your vehicle. Windshield's not already broken. The side is not bent. So we've gone through some of the witnesses: Zamora, J.B. Jones, Carrasco. I know I mentioned what he said before, but let's just focus a little more closely. He's a mechanic. The second person that she called after the crash, while still in the car, she calls her boyfriend and then Mark. He testified that she was panicked. He said, "It woke me up between 6 and 7, wasn't sure at the time." We have the phone records to establish the time of that call. And he tells Officer Stokes, he says, "Did she tell you she hit a kid?" "Yes, she did." That's what he said. Now in court, he says, "I don't remember what she said, but she never said that." So do with that what you will, but his in-court testimony I submit to you isn't reliable. It's what he told Stokes. We know the text messages then began, "I can't wait till after hours. It's going to kill me. A cop lives above me. I can't wait for him. Is there any way you can do that?" I mean, this is at 12:54. This is well after even she admits she knew she was involved in a crash involving a child, and yet her guilty conscience at this point is still causing her to want to cover this up. Okay? I'm paranoid. My neighbors are looking at my car. They probably saw the news. He says, "I need a picture of the glass. There's 4 different types." She says, "I can't take a picture. She can't go outside, take a picture. That would draw attention." All right, Dr. Veronica, the cause and manner of death, blunt force trauma caused by motor vehicle crash. Of course, she admits to being the driver. It's Deputy Allen and Miklosh at the jail. Gardunia retrieved the data from the car, location and speed data. And then we had Alfonso Fernandez today. And this is that exhibit 17, just simply putting them together, the outgoing and incoming based on the times. And so we see at 6:29:35, which would be 10:29 GMT, she calls for 8 seconds her boyfriend. So 6:29. Then that's an outgoing call. Then he returns the call, and they talk for 35 seconds. That call begins or is received at 6:30:35, and they talk for 35 seconds, which would then put them at about 6:31 and 10 seconds. So we're just a couple. 6:31, about 2 minutes shy of the crash. The crash is 6:33:57, and then at 6:34:28. So about 30 seconds after the crash, she calls her boyfriend back, talks to him for 3 minutes, and then, while still driving, calls Mark. This is before she gets home, and we know that based on her location data that we've already discussed. She absolutely saw the crash, and she saw her striking Yesenia because we have an image from inside her car that night at about 3 o'clock that night. She makes this video, and we can see we can see that her camera's perspective, which is obviously in her hand as she's behind the wheel driving. So we see this directly over the steering wheel. She's 5'2", she's not 3'2". She can see over the steering wheel, and she can see off to the left and to the right. Officer Stokes testifies. He does the traffic crash reconstruction, look at the scene, analyze the scene, where's the evidence scattered, look at the grass, look at the road, look at all of that, review the surveillance video. In this case, we didn't see the crash happen on the video. Begins to search for the driver and the vehicle, begins receiving tips and calls, right? And then examines the vehicle upon it being located and obtains warrants for the cell phone and for the infotainment center. Almost wrapped up here. Proof of guilt beyond a reasonable doubt. The sound of the collision that you hear and that we all hear, and the damage is not caused by a pothole. That car never went off the shoulder. You can see from the videos, she's in the road. She's just bypassing the bus, though that lane is 10 feet wide, the northbound lane. The southbound is 9.9 or 9 feet 9 inches. Her car is 6 feet wide. She's not off in the shoulder. The grass doesn't show that. There are no tire marks that show that. There's tire marks showing cars from Skylark, but she is in the road, and it's not a pothole, and a pothole wouldn't cause that kind of damage. Her headlights are working, so she would see who's directly in front of her. Although she testifies that she never saw any of those children, you have to ask yourself, is that reasonable, and does that pass the common sense kind of smell test? And I submit it doesn't. School bus lights are certainly flashing, which she's admitted that she did see the school bus. That she hits Yesenia in a head-on collision, killing her, and that she then left the scene. So you're not to speculate, imagine, or force a doubt where there is none. You know, the standard is proof beyond a reasonable doubt, and it says a reasonable doubt is not a speculative, an imaginary, because any person in any situation can say, yeah, but what about this, that, and the other thing? It always force doubt where there is none. In this case, there's no reasonable doubt as to the facts of the case. You know exactly what happened. You know the time that it happened. You know the facts. It's not in dispute. And you have no reasonable doubt that the acts constitute the crime. What the evidence shows, what the facts show that she did, that meets the elements of those two charges. She's charged with that. That's what the evidence shows. So based on that, you have proof beyond any reasonable doubt. This is the verdict form. Lastly, count one. There's 2 counts. You're to determine either guilty of leaving the scene of a crash involving death or not guilty. That's what you decide. The evidence shows she was involved in the crash, she left the scene, and that she certainly knew of the injury based on the circumstances, but it's not even what she subjectively knew. Because remember, the element is knew or should have known. It's an objective standard. So if you find that a person in the seat of the vehicle where she was situated, involved in that type of head-on collision, should know of injury, then that's been proven. Okay? It's not a subjective what she believed, it's what a objective person would know given those circumstances of the injury to the child. So yes, guilty. Then you come down, if you find her guilty, you answer these next 2 questions. The first one has to do with, in committing the offense, did she cause the death? Yes. Check the box. Finally, was the victim in this case a pedestrian? Yes. Then we move on to count 2. She's either guilty or not guilty. She's admitted she drove recklessly at the time of the crash. Therefore, she is also guilty. And I ask you to find her guilty on both counts.
Thank you, Mr. Moore. Mr. Stone, your closing arguments. Now, folks, if you've been taking notes at this point, you can put your pads down, because everything I'm about to read to you is going to be handed to you in a hard copy, and that will be given to you, so you can refer to it. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Ariana Aleja Colon the defendant in this case has been accused of the crimes of leaving the scene of a crash involving death and vehicular homicide. To prove the crime of leaving the scene of a crash involving death, the state must prove the following 4 elements beyond a reasonable doubt. 1. Ariana Colon was the driver of a vehicle involved in a crash occurring on public or private property, resulting in the death of YG. 2. Ariana Colon knew that she was involved in the crash. 3. Ariana Colon knew or should have known from all of the circumstances, including the nature of the crash, of the injury or death of YG. 4. Ariana Colon willfully failed to stop at the scene of the crash or as close to the crash as possible and failed to remain until she had completed 2 things: giving identifying information to any police officer investigating the crash and rendered reasonable assistance to YG. Willfully means knowingly, intentionally, and purposefully. Identifying information means the name, address, vehicle registration number, and, if available and requested, the exhibition of the defendant's license or permit to drive. Reasonable assistance includes carrying or making arrangements to carry the injured person to a physician or hospital for medical treatment. A vehicle is involved in a crash if it collides with another vehicle, person, or object. A vehicle is any device in, upon, or by which any personal property is or may be transported or drawn upon a highway. Now, if you find that Ariana Colon committed the crime of leaving the scene of the crash involving death, you must then determine whether the state proved beyond a reasonable doubt that she caused the death of YG. If you find that Ariana Colon committed the crime of leaving the scene of a crash involving death, you must then determine whether the state proved beyond a reasonable doubt that YG was a pedestrian. Pedestrian means any person afoot. To prove the crime of vehicular homicide, the state must prove the following 3 elements beyond a reasonable doubt. 1. YG is dead. 2. Death was caused by the operation of a motor vehicle by Ariana Colon. 3. Ariana Colon operated the motor vehicle in a reckless manner, likely to cause the death of or great bodily harm to another person. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. The state does not have to prove the defendant intended to harm or injure anyone. However, the reckless operation of a motor vehicle requires the state to prove more than a failure to use ordinary care. A reckless manner means in a willful or wanton disregard for the safety of persons or property. Willful means intentional, knowing, and purposeful. Wanton means with a conscious and intentional indifference to consequences and with the knowledge that damage is likely to be done to persons or property. A motor vehicle is a self-propelled vehicle not operated upon rails or guideway. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime in which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness will give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the or the testimony of any witness. Now, these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, you may find the defendant guilty as charged or not guilty. Now, if you return a verdict of guilty, it should be for the highest offense on the verdict form that's been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Now, verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. Now it reads as follows. We, the jury, find Ariana Alea Colon as to count one. You're instructed to select only one. Guilty of leaving the scene of a crash involving death, as charged in the information, or not guilty. Now, if you find the defendant guilty of leaving the scene of a crash involving death, then you must answer the following special interrogatories. We, the jury, find beyond a reasonable doubt that in committing the offense of leaving the scene of injury, leaving the scene of an injury involving death, Ariana Colon caused YG's death. Check on 1, yes or no. We, the jury, find beyond a reasonable doubt YG was a pedestrian, and then again, check only 1, yes or no. Page 2. That's count 2. Again, check only 1. Guilty of vehicular homicide is charged in the information, or not guilty. And then there's a place for the foreperson to sign and date for the verdict. Now, separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on the verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in the case, you must tell me by giving a note to the court deputy. Now, many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those type of electronic devices into the jury room. Now, leave those devices on your seats where they will be guarded by the court deputy while you deliberate. Now, if you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in your note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. And you may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Now, at this time, take your notepads with you, follow the deputy to the jury room, and if I can have Mr. Goodspeed and Ms. Matos just remain behind. All right, Ms. Matos, Mr. Goodspeed, you were selected as our alternate jurors, which is a very important role because this case, as you are well aware, from jury selection on Monday all the way until today, if any of the other jurors were to become ill or just not return for any reason, it would have been your job to step in and take their place during deliberations. But all 6 have made it to the deliberations. At this time, I'm going to discharge you. Now, if you wish, you may stay and wait with the rest of us for the verdict, or if you want to leave, you are free to do that. And if you want to know what the verdict is, just leave your phone number with one of the deputies. I'll make sure that they call you. Now, if you give the badge and the notepad to the deputy, they'll give you all of your personal belongings back. We do have lunch for you, so you can also have that at this time. But if you see the deputy, he'll return your personal belongings. Thank you very much for serving. Council approach. Let's look over the exhibits. There was some typo on the one instruction I'll fix and have you checked.
Yeah. That's what me and Greg was talking about. No. After they get done. Yeah, but he said about an hour before they start the
No. I'm just looking. I'm just looking to see if I left anything behind.
I double checked that.
All right, good.
I'll get it.
Obviously, you walked through it down. Excuse me. Excuse me. Whoops, sorry. Yeah, we're not concentrating here. We have to let one do so. That's a quick one. Okay, good. Oops, sorry. Medical history. We almost have clear passage. But they have. Get by with a few casualties. Collateral damage. I don't know if real or like over. That's what I He pulled it that way. What? Yeah, do I leave her? I'm gonna go over here, so I'm not real rude to the point. Ouch, my goodness. Just destroying crazy cat. Excuse me, pardon me. Okay.
His last page is 8, yes.
All right, counsel, if you are going to leave the courtroom while we wait for a verdict or a question, make sure that you leave a cell number with the clerk so you can be reached quickly in case of question and verdict. All right, so all evidence, all exhibits.
We're just redacting the one document that needs to come out at the time.
And we are, Mr. Miller, Mr. Stone, states 10, that's the autopsy photos. Those are the redacted ones with the cropped.
Yes, I created that list and then provided that to the clerk who,
You have Jim as 10.
you recall the switch we made. I can always double check, but I remember doing it.
16 photos.
You didn't talk to me yesterday so much.
I was in a big old ass hurry. Oh my God.
I'm just kidding.
I'm so crazy. Hey, do you guys have somebody down at West Palm Beach today in the press conference about
All right, no objections?
Okay.
well, crazy stuff?
All right, gentlemen. We'll be in recess until a question or a verdict.
They ordered lunch for everybody. Okay, so 30 minutes. Right, that's what he said. That was smart.
All right, please.
Angela, what you doing?
Yeah, I had to write about that stupid trial that Snyder was involved with. Yeah, they got another trial coming up March 25th. It's supposed to last like 7 to 10 days and fucking 13 more people. That's very impossible.
Are they deliberating now or are they eating? They're eating now.
Because they don't have all the evidence. I'm getting ready to take evidence back. I can't even talk about it.
Can't say that they're delivering it, it's eating.
They gotta eat their food.
Yeah, they can't deliver it when it's delivering.
Excuse me.
They gotta have their
So
grub.
theoretically,
Did
even
they
though
do
they
lunch
left
first?
at 12:10, they're not really delivering.
And kick it back about 20 to 25. I'll say about
12:30.
half an hour.
Because we got 12:20 now, so
Kick it
I'd
up about a
say
half an hour.
12:45.
Then start.
Okay, thank you.
I'll let them take it back.
No, they don't want to get no food on evidence, so we're not going to.
What did he say?
What
did they get?
Yeah,
What they get? You know?
They got Jimmy John's. I don't know what they ordered individually.
What they got? Jimmy Jones?
Jimmy John's is good.
Yeah.
Yeah, it's fast.
It's fast.
Fast food or fast first?
There you go.
All right.
Is the mother here?
She was here.
Just
Okay,
teasing.
is that there was like 6 women that left all at the same time? That's the story.
She kept crying.
Oh,
She
I
kept
bet.
running out. It was like really hard for her. Let me get my, let me
I
unplug
can't
this.
even imagine. You know what? Don't bother. Because
It's not hard. It's just
Yeah?
me. Yeah, you know what? I'm trying to
Because if I
unplug
can't
my-
record it, then, you know, I mean, I don't know if I want to just take notes. It's okay, because for the purposes of my story, the verdict is not doing anything. You know, I can just say that she took the stand.
Actually, because you can hear, okay, all right, that's fine. Yeah, I don't want to bother you with it.
Do you guys just bring all your stuff right outside and then come and set everything back up, or can we just
I've
leave
never
this
written a
stuff?
word on this story. You know, because you know what, it's not long. It's like,
Yeah. I mean, are you gonna just leave your stuff here, or are you gonna put
step
it?
outside in the hallway.
The editing part,
Are they
they
keeping
close
the
the
phone open?
door, they lock it.
Yeah.
Or I'll leave it.
Yeah,
separate.
I'll
yeah,
put my,
you find them in the
Are
left.
we gonna be able
but
to,
the camera,
are we
tripod,
gonna be able to come
leave
back, or are
everything.
you gonna
You
lock
need to
it?
lock this down, so we shut ones out.
Okay.
I'll reopen if they have a question or verdict, we'll open it up and call everybody in.
Okay, so basically we're gonna have to wait in the hallway then.
Yeah.
So we cannot be.
Which is,
I'm gonna leave my camera.
he's gonna lock up.
Oh, you're gonna lock up?
I'm leaving my camera.
They left it yesterday.
I brought the stuff here because I thought they're gonna be up.
We just need the laptop and
Yeah.
Yeah, I mean, I'm just
Do you need help?
Thank you.
Whose is this? This that's your strip?
I'm gonna pass you right.
Yep, no worries.
See more, at least call over there, see if somebody can bring it.
They're gonna lose.